Okay, so do I have my camera? Oh, hey, cool. I can have my camera up there. Look at that. And you just don't cover this up. Okay. My hair looks terrible from that angle. Okay. Well, this is the Supreme Court case of Warner Chappell Music v. Nealy. This is regarding the 3-year statute of limitations and how that applies to claims for damages. So there's a 3-year statute of limitations, and you would think that that means you can only file claims for infringements that arose or accrued or occurred. These are legal words within 3 years of the filing of a lawsuit. If I file a lawsuit on January 1st, we'll just say January 1st for ease of in these examples. If I file a lawsuit in 2024, I should only be able to go back to infringements from 2021, from January 1st, 2021 and onward. Not anymore. Now the standard is when the plaintiff could have reasonably discovered the infringement. That's the 3-year statute of limitations. The plaintiff simply has to sue within the 3 years after they reasonably should have discovered the infringement. So a clear example would be YouTube. If I publish an infringing video to YouTube with the correct title, not hiding anything, and I'm making an infringing use, but I'm not also hiding the infringing use. I haven't altered the video, I haven't removed a watermark, I haven't changed the aspect ratio or flipped the video or something, or made it fuzzy or changed, just making infringing use and not hiding it. The plaintiff should have discovered it right away, or reasonably shortly after publication. Now, if I publish a video on YouTube that's infringing, but I've removed the watermark, I flipped the video, I've changed the resolution, I've changed the pitch or the tempo of a music piece or a song, I've maybe cropped in or cropped out, you can do that now, altered the video, hidden information, changed the title, etc., then maybe the plaintiff can argue, or probably the plaintiff can argue, that they didn't need or couldn't discover the infringement. They didn't need to discover the infringement right away. They could have waited until they reasonably could have discovered the infringement on their own. So coulda, woulda, shoulda, basically. They could have discovered it on their own. They should have discovered it on their own. They would have discovered it on their own if only they looked. And so that would be the standard now. And part 2, and damages are not tied to the 3-year statute of limitations. So if you can sue over a timely accrued copyright infringement within 3 years of the statute of limitations, you can also now look backwards to how much damage that infringement has done beyond the 3 years. So that's a big deal. That's going to give plaintiffs' attorneys a lot of money to go after. That will get plaintiffs' attorneys interested in copyright. You will see more copyright infringement lawsuits, and you will see more infringement lawsuits for larger damages because they can look further back in time. Now, without further ado, what did the Supreme Court have to say in their 12 pages in these? I don't like these tiny pages. They don't translate very well to screen. This is the syllabus, so this is the summary. Under the Copyright Act, a plaintiff must file suit within 3 years after the claim accrued. On one understanding of that limitations provision, a copyright claim accrues when an infringing act occurs. But under an alternate view, the so-called discovery rule, a claim accrues when the plaintiff discovers, or with due diligence, should have discovered the infringing act. That rule enables a diligent plaintiff to raise claims about even very old infringements if he discovered them within the 3 years prior to the suit. In this case, respondent Sherman Nealy invoked the discovery rule to sue Warner Chappell Music for copyright infringements going back 10 years. So this is not Warner Chappell plaintiff versus Nealy defendant. This is Nealy plaintiff versus Warner Chappell defendant. And the names are flipped in the title because of who's appealing. I mentioned Warner Chappell's the one appealing. Nealy argued his claims were timely because he first learned of the infringing conduct less than 3 years before he sued. In the district court, Warner Chappell accepted that the discovery rule governed the timeliness of Nealy's claims, but it argued that even if Nealy could sue under that rule for older infringements, he could recover damages or profits for only those occurring in the last 3 years. The district court agreed on appeal, interlocutory during litigation appeal. The 11th Circuit reversed, and now the court here, the Supreme Court, is going to agree with the 11th Circuit. Held, the Copyright Act entitles a copyright owner to obtain monetary relief, for any timely infringement claim, no matter when the infringement occurred. No matter when the infringement occurred. The Act's statute of limitations establishes a 3-year period for filing suit, which begins to run when a claim accrues. Here, the court assumes without deciding upon its discovery. So the court is not deciding the discovery rule, but it's going with it. So that's okay, I guess. That makes the discovery rule valid, but the court is not further defining the discovery rule. They're focusing on the damages. That provision establishes no separate 3-year statute of limitations on damages. If any time limit on damages exists, it must come from the Act's text, the remedial sections, but those provisions are merely state that an infringer is liable for either statutory or actual damages or profits. There's no time limit on monetary damages, so a copyright owner possessing a timely claim is entitled to damages for all infringement, no matter when the infringement occurred. The court's decision in Petrella, a different case that I guess they'll cover later, does not support a 3-year damages cap. The court noted that the Copyright Act's statute of limitations allows plaintiffs to gain retrospective relief running only 3 years back from the filing of a suit. Taken out of context, that line might seem to address the issue here, but that statement merely described how the limitations provision worked in Petrella, where the plaintiff had long known the defendant's infringing conduct. The court did not go beyond the case's facts to say that even if the statute of limitations allows a claim for earlier infringement, the plaintiff may not obtain monetary relief. The plaintiff may not obtain monetary relief. Unlike in Petrella, Nealy has invoked the discovery rule to bring claims for infringing acts occurring more than 3 years before he filed suit. The court granted certiorari in this case on the assumption that such claims may be timely. If Nealy's claims are thus timely, he may obtain damages for them. So Nealy's claims are not resolved because this is an interlitigation, an interlocutory appeal. His claims have not been determined whether they're timely or not. So assuming they're timely, the Supreme Court now decides that he can seek damages beyond the 3-year statute of limitations. That is very powerful, and that's going to change. That's a wind-changing change in the law. Game-changing. It's a game changer for lawyers, for plaintiffs' lawyers, who are now going to be able to look back to many, many thousands, if not millions of dollars more in claims. When they discover infringement and can prove that they've discovered it timely, they can now sue for all damages for all time, not just 3 years. Very important. So we'll go over the whole. So I'll go over the whole thing in my live stream at 10 a.m. Today, Sunday.